Here's your name, Mr. Carston. Your name, Mr. Carston?
Yes, sir.
Okay, just one moment. Officer, could you let Mr. Church know that you need to get moving?
Yeah. He's in the room on the side.
Yeah, thank you.
Where do we go? We're doing Carston? Okay.
Mr. Church, I can give you more time with Mr. James. It's just we got Mr. Carston present.
I'm ready on both.
Okay. So we'll go on the record in Google versus Kyle Carston. This is case number 246756. The record should reflect Mr. Carston's present today by video from the Otsego County Jail. I can have counsel put your appearance.
For the record, Your Honor, my phone bill.
Thank you, Honor. Richard Church, appearing on behalf of Mr. Carston.
Thank you, Mr. Church. This was set for our scheduling order. I do see that there's been an objection filed regarding lab reports, but can you just give me a status of the file state?
Yes, Your Honor. So we have consulted with a few different experts. I would ask the court to docket this for a trial. I would suggest a final status conference, probably in about 90 days, followed by a trial after that. I anticipate that everything is in line, that we'd be ready at that time, but obviously, hiccups can happen.
Do we need to have a hearing regarding this lab report issue?
I don't think that there's a necessity for a hearing. So the prosecutor filed a motion. The motion identifies that they're seeking to admit the lab without any basically foundation from the lab person. The court rule allows them to do that, but I think if I file an objection, that's the end of it. I don't think they get to argue that they can bring it in without it over my objection. And if the prosecutor wants to weigh in differently, he can. But I don't think it's an issue that requires a hearing.
Okay, Mr. Rowland.
Judge, if this goes to trial, we'll have the expert for the lab. That's a given.
Okay, so it's a non-issue.
It's a non-issue. I mean, we do that for the purposes of convenience. If there's an objection to it, then obviously we'll have the expert here for it. I don't believe this is anything that's going to require a Daubert hearing or anything of that nature.
Okay, great.
And I would indicate for the record, as we get closer to trial, I expect that Mr. Rowland and I will have discussions on what witnesses are or necessary, and again, exactly what things it is that he's seeking to introduce through that.
Okay, so we're looking at a trial date set out about 4 months from today.
I think that would be appropriate.
Mr. Rowland, is that sufficient time for the people to be prepared?
Yes, Your Honor.
Okay, and then previously we discussed a duration of 5 days. Mr. Trush, do you agree with that at this point?
I would think that's probably a pretty accurate guess.
Okay, Mr. Rowland, do you think that'll be enough time?
I believe it will. We might be able to get it in 4, but I think to be on the safe side, I would say 5.
Okay, so we'll set it for 5 days, based on that scheduling as we discussed here today. Mr. Roll, anything else I can address for your side today?
No, Judge. There is the defendant's other case, and actually there will be a motion. People will probably be filing because there's evidence in regards to the forgery case that we've now realized are relevant to the allegedly relevant to the defendant's motive for committing the crime in this case.
Mr. Trush, anything further from your side?
No, not at this time.
Okay, Mr. Carston, have you been able to hear all of that?
Yes, sir.
Do you have any questions about how we're going to proceed with your case?
No, sir.
Okay, all right, thank you. That's all for this hearing today, and we're going to go ahead and disconnect from the jail at this time. People versus Ryan James, case number 226265.
For the record, John, we'll have people.
Thank you, Your Honor. Trush, on behalf of Mr. James.
Okay, the record should reflect Mr. James is present here in court today. Mr. Trush, can you give me a status on this?
Yes, Your Honor. We would like to have this set for a trial. I'd ask for a final status conference prior to the trial. And I would indicate there's no specific time frame necessary on this.
Mr. Rolla, how much time do the people need to be
I'm
prepared?
looking at that now, Judge. In this particular case, we have 9 witnesses, but with the nature of the offense, I think it's perhaps might be able to get it in 2 days.
Mr. Trush?
I would tend to think 2 days is a sufficient time.
And Mr. Rolla, any particular period of time that you need to be ready?
No, Judge, as long as it's not any longer in the month of November, the first week in December, where I know some of our witnesses may be otherwise already taking time off vacation and not available. I don't think it's going to be an issue. Thank you.
Mr. Trush?
No specific time frame that we're looking for.
So we'll set this for a 2-day jury trial at about 90 days out, or as available for the court schedule. I will set it for a final status conference prior to the trial date. That'll be the plea cutoff. So Mr. James, to the extent that you want to further consider any plea offers, that final status conference will be the last day to do that. If we don't have any agreements on that date, then we proceed to trial. Mr. Rolla, are you anticipating any motions being necessary prior to?
I don't believe so, Judge. I don't see any.
Mr. Trush?
I don't anticipate any.
All right, so the court will send out notice of the trial dates as well as the final status conference, plea cutoff. Mr. Rolla, anything else I can address for your side?
Not for the people. Thank you.
Mr. Trush?
Not from defense. Thank you.
Mr. James, do you have any questions about?
I'm sorry, Your Honor. Thank you. I appreciate you.
Okay, thank you. Okay, next hearing set at 9:45. That's a sentencing hearing for Mr. Cole, so we'll be in recess until that time. On the record in People versus Cole, this is case number 246749. The record should reflect Mr. Cole is present here in the courtroom today. If I could have counsel put your appearances on.
Thank you, Your Honor. For the record, my call on people.
Good morning, Judge John Steffi on behalf of Mr. Cole.
Thank you. This is the date and time set for sentencing in this matter. Mr. Cole, have you had a chance to go through the pre-sentence report and talk to Mr. Steffi about that?
I haven't.
I'm sorry, what's that?
I haven't.
You have not?
No.
Okay.
We have not had the chance to discuss the PSI, so as your honor knows, we had a stipulated agreement to adjourn this due to the fact that I only received the PSI on Thursday afternoon, was out of state all day Friday until last night. So it's important that we discuss the PSI. I do have some guideline scoring challenges as well. So at a minimum, if your honor will not grant an adjournment, I would ask to pass the case, so I may discuss it with Mr. Cole
Okay. How much time do you need to do that this morning?
for like 20 minutes to 15 minutes.
All right. We'll take a break until 10 o'clock and then we'll come back on the record then.
Okay, thank you.
On the record in People versus Paul. Mr. Paul, did you have a chance to go through the pre-sentence report with Mr. Steffi? Yes, sir. Okay. And Mr. Steffi, before we get to the scoring challenges, are there any additions, deletions, or corrections?
Judge, we don't have factual corrections or additions, et cetera.
Okay. What are the challenges to the scoring?
Thank you, Judge. Under PRVs 1 and 5, those should both be 0 due to the 10-year gap in between offenses. There's an OWI from 2012, and then nothing until this case, but for a state of Georgia, appears to be a misdemeanor battery or domestic violence. Different statutes than we have, so I can't tell you exactly, but it says battery family violence. So I assume that's got to be DV basically for us. But that was dismissed after successfully completing that Georgia diversion program. So that does not count as a conviction under the law for scoring guidelines purposes. People versus Wilson, appellate court unpublished case number 349242. Because the defendant's DV matter was discharged under MCL 769.4a, there was not a prior conviction under PRV 5. So without that 2017 Georgia dismissed case, which was dismissed on April 10th, 2019, there's more than a 10-year gap, and there should be no score under PRV 1 and PRV 5.
Okay, so the scoring of PRV1, you're saying is dependent on the DV charge being scoreable.
Yes, without that, as it is a dismissal, and our courts have also told us in James, which was a 2005 appellate court case, that a adjudication or conviction, even though it's not a conviction under 7411, is also not scoreable for sentencing guidelines. So I think the law is clear. Because it was dismissed, it's not scored.
Okay.
And can't make that gap.
Mr. Rowland.
With all due respect, Judge, as the court's well aware of the sentencing guidelines, matters which are deferred, as that case was under the Georgia statute, are scoreable under the guidelines because it's still a conviction. It doesn't make any difference if it was later dismissed under the deferral. It still can be counted as a, for example, HYTA offense matters that are dismissed also can be counted for the purposes of the guidelines. The argument being here in this case that there's a 10-year gap between his current offense and his 1998 assault and battery. However, he does have his 2012 drunk driving. He's got a February 2000 federal possession of felony of a firearm and furtherance of drug trafficking. Those two offenses wouldn't be scored, but the remainder of the offenses can be scored, even with that 10-year gap.
There's nothing within the 10-year gap without the dismissal from Georgia.
So without the 2017 conviction, then the next one we have is 2012. So wouldn't that be beyond the 10-year gap?
It would be if you couldn't count it. But
No, I get it. But if you can't count the 2017 one, then the others couldn't be scoreable. Is that correct?
because you'd have a 10-year gap. Except there's one quite issue though, is that's looking at his criminal history. As the court's well aware, you have to also look at his driving record, and where he has driving offenses during that time period, the 10-year gap rule is then set aside, and you can continue to count the offenses.
Okay, but there still isn't anything between 2012 and now.
On his criminal record, not on his driving record, which also can include civil infractions, including careless driving, speeding, and other offenses, because as our appellate courts, under published decisions, as opposed to unpublished decisions, have indicated that it has to show that the defendant had no other offenses. You can also even include circumstances where the defendant committed a PPO violation, for example, where he had that one. That's what our law allows for. And again, I don't have his driving record in front of me right now. I'm pulling it up now, Judge, if you'd like me to do so.
Well, let me take a look at the statute, and the case is cited by Mr. Steffi. So we'll take another short recess. And, you have any other scoring challenges, Mr. Stafford?
Sorry, Judge. Yes, I do. Offense, OV 13 is scored at 25 points in this case. Using, I assume, the criteria of 3 or more crimes versus against a person. I believe that should be 0 points in this case. We're talking about sentencing on an R&O right now. There could be one other crime against a person involved in that, as there was another count of R&O that was dismissed. But there are not 3 or more crimes against persons in the 5-year period.
Mr. Rowe?
Judge, you count the other R&O, and also in addition to that.
I should note that during plea discussions, Mr. Roll and I were pretty much in agreement to the scoring guidelines as would have been if Your Honor grants these scoring challenges. So these are not, we both thought there was a 10. Yeah.
And Judge, I am now had an opportunity to look at the defendant's driving record, and he had a 9/12/22 conviction for operating while intoxicated too, which also comes into play in regards to the 10-year gap. As far as the situation with the 3rd assaultive offense, I believe he has actually 2 other R&Os. One that is this particular case, and I believe one more. It's indicated in the PSI.
Well, here, this is what we're gonna do. I think maybe both parties in the court could benefit from some briefing on this, so I think what I am gonna do, Mr. Steffi, in light of the challenges and in light of, I think what Mr. Rolla probably would like is an opportunity to respond. I'm gonna ask that you prepare a brief outlining your challenges to each of the scoring guidelines. Mr. Rolla, you'll have an opportunity to respond to that. The court will reset this for sentencing at its next available date. We'll send that out to them.
And that's for the record. The other resistant instructing was the August 13, 2024 matter, which was then dismissed as part of a plea, but as the court's well aware, it's not an acquittal, and it can still be used for scoring purposes.
Okay. All right. Thank you. That's all for today.
Should have been in their office on Friday.
All right. Kapanke versus Bargy, case number 2419862.
Yes, sir. I just question, is the House matter still going at 11:30?
Yes,
Okay,
and we have McEwen at 10:30.
correct, Judge, and I'm ready for that as well. So I will turn off and move out. I'm gonna be able to get to it as 10:30. I'll just vacate the space for
Thank you.
without shutting off the laptop.
All right, this is file number 2419862. Ma'am, are you Jody?
Yes.
Kapanke?
Yes.
Yes. Mr. Bargy is here, present. And we're set here today for a hearing. The court granted a personal protection order to Ms. Kapanke. Back on October 1st, Mr. Bargy's filed a motion to terminate that so today is the date set for a hearing on that motion. So I'm just gonna go over the ground rules with each of you as we go forward. First of all, Ms. Kapanke, are you asking for this order to stay in place?
Yeah.
Okay. So I'm gonna place both of you under oath. I'm gonna take testimony from each of you. Ms. Kapanke, because you're the one who asked for the order in the first place, and I'm the one who's asking for it to stay in place. The burden is on you to show the court that it does need to stay in place. So you'll have an opportunity to testify first and tell me about why you got the order and why you think it needs to stay in place. Mr. Bargy, you'll have an opportunity to testify and tell me why it doesn't need to be in place. And then Ms. Kapanke, because you have the burden here going forward, you'll have the opportunity to respond to anything that Mr. Bargy has to say, okay? Just a couple of ground rules. First of all, I'll give each of you a reasonable opportunity to tell me what you think is important about the case. I'll try not to interrupt you, but if you're going into matters that aren't relevant to me or aren't necessary for me to know in order to make a decision, I may stop you and try to redirect you, but otherwise I'll give you a reasonable opportunity to tell me what you think is important. I'll ask that you don't interrupt me. I'll also ask that you don't interrupt each other. We're making a record of this proceeding, and if people are talking over each other, it's hard to make a transcript later if we need to. Also, please don't address each other across the aisleway there. If you have any comments, you should address them up to the bench here, to me, not to each other. Ms. Kapanke, do you have any questions about how we're going to proceed? Mr. Bargy, do you? No. Can you both raise your right hands, please? Do you both solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Thank you. All right, Ms. Kapanke, specifically what was happening in October that led you to seek the personal protection order?
Robbie kept coming back and forth past my home, all hours of the night, and then he came back the next day, which is not normal,
Okay. How did you know that it was him?
because I've seen him.
Like personally or a vehicle? Or?
No, personally, when I come out on my back porch, because I smoke, I don't smoke in my home. So I was out on my back porch, I was smoking, and I seen his vehicle come by. At first, I was like, was that his vehicle? And I was questioning myself, because we had court that morning. And normally, him and his family come here, and then they leave after court. So I stayed out there, I waited for him to come back, and I clearly seen it was him driving that vehicle. And so then I stayed out there because I was afraid that he was gonna come and do something to either me, my home, my children, to anything. So then he came back by again, and then he left again. That is when I called the police, because there was no reason for it, other than him trying to threaten or intimidate
threatening, intimidating, harassing conduct that would make a reasonable person feel that way, and that Ms. Kapanke actually did feel that way as a result of his conduct. What I think are some pertinent facts here, and number one, you know, I would say, looking at this in a vacuum with no other factors, Mr. Bargy, your version of what took place is certainly plausible. One of the times that you drove by, just looking at the pictures that you submitted with your petition, Ms. Kapanke, was about 4 minutes. That's kind of consistent with getting there and then turning around and leaving at the park. One was 9 minutes in duration. The other was 35 minutes in duration. So, you know, again, looking at this in a vacuum, I think Mr. Bargy's version is certainly plausible. But I'm not looking at this in a vacuum. There's other context here. First of all, there is the custody case, which I'm well aware of. I sat through a number of days of testimony. It's certainly a hotly contested case, and this Ms. Kapanke has certainly been involved in that. You know, there are lots of places to go for nature walks around here. I think it's interesting that the place that you chose to go happened to be the only one where you would have to drive by Ms. Kapanke's house to get to it. Particularly, you know, if you're staying at Treetops, there's a lot of areas to go for walks around there, including on the Treetops property, which is probably more natural than Aspen Park, but you chose to go to Aspen Park. Same thing with Waters. So I find that that's an interesting coincidence. The times that you were there, you know, this is the end of September. One of the times was at 11:15 at night. The other time was at 9:54. So 10 o'clock, 11 o'clock at night, well after dark at the end of September, doesn't seem like a logical time to me to take your kids for a nature walk. So I find that to be an interesting coincidence as well. And, you know, Mr. Bargy, I heard your testimony in the custody case. I heard your testimony today. I don't find you to be particularly credible. A lot of your testimony doesn't match up in both contexts, and I'm not required to ignore my impressions of your truthfulness and credibility in other cases. And the fact is, you are charged with a number of serious weapons and drug charges. And so when you put all of that together, I think the driving by Ms. Kapanke's home at the times that you did and the manner that you did would cause a reasonable person to feel threatened, harassed, or intimidated. And Ms. Kapanke certainly testified that those actions did make her feel that way. So the court finds that there is a basis for the personal protection order to remain in place, and it will remain in place. And the motion to terminate is denied. So that order will remain in place until its expiration date. Mr. Bargy, I'm going to ask that you and your parties just remain here, give Ms. Kapanke an opportunity to leave the courtroom, and ask that you just stay here for about 5 minutes. And Ms. Kapanke, you're free to go. Thank you.
Thank you.
Sir, I said Mr. Bargy and his parties. Are you with Mr. Bargy's?
They're with me.
They're with you. Okay.
My parents.
All right. You were sitting on that side, so I wasn't sure. Okay. And Mr. Rolla?
That's why I had our crime victims' rights advocate walk around.
Oh, thank you.
For the court's benefit.
All right, and then I'm going to bring the parties in on Ms. McEwen's case. Ms. McEwen, are you able to hear me okay?
Yes, sir.
Okay. All right, and Ms. France, are you able to hear me?
I am, Your Honor. Thank you.
Okay. All right, we're on the record now in People versus Amanda Faye McEwen. This is case number 216047. The record should reflect that Ms. McEwen is present today by video from the Department of Corrections. Her attorney, Ms. France, is also present by video, and Mr. Roll is present here in the courtroom today. And this is Ms. France, your motion on behalf of Ms. McEwen to restore her appellate rights. Is that correct?
It is, Your Honor. Thank you.
I did have a chance to review your motion. Mr. Roll, I had an opportunity to review your response. Ms. France, anything that you wanted to state for purposes of oral argument here today?
Your Honor, I don't know that I received a response from Mr. Rolla, but I'm still prepared to go forward.
Okay, go ahead.
Thank you, Your Honor. I think my motion is pretty clear when I laid it out. I will state for the record, we got some of the transcripts after I filed this motion from original trial counsel, but half of them we got back were destroyed in the mail, and those were his only original copies. So we still don't have everything. I know my staff was working with the court staff on getting everything and verifying we had all the transcripts, but to my knowledge, I think we might still be outstanding one from district court. But at this point, it is impossible for me to go ahead and give her any legal advice, let her know if there are any proper scoring challenges when I didn't have all the information within the 42 days. So by signing the order granting the relief, the court is just giving us a new clock effective immediately for 182 days. I don't know if we're going to be having anything to appeal or not, but I need all the information to make an informed decision to relay on to my client. Thank you, Your Honor.
Thank you, Mr. Rolla.
Thank you, Your Honor. A couple of points. First and foremost, in regards to the transcript, under the court rule and under statute, the respondent's responsible, first of all, for requesting the transcript. The court knows that. More importantly, though, the person requesting it from is not going to be from the court. They're going to be requesting it from the court reporter. They can get copies. That can be done. That's not an issue at all. That was never done. But perhaps the greatest importance in this particular case, and the reason why the motion to reinstate appellate rights should be denied, is because there were actions taken specifically by Ms. McEwen and or not intentionally not taken by Mrs. McEwen that's resulted in this. This is not the first appellate counsel. This is not the second appellate counsel. This is the third appellate counsel, Ms. McEwen's fourth counsel, as I indicated, and as indicated specifically in the register of actions attached to my response, which, by the way, I did send to, our office did send to defense counsel, appellate counsel back Friday, using the email address that she has listed under the bar journal. Whether that's correct or not, that I can't speak to, but it's the one that she had listed. That's where it was sent, so she did. But in any case, it's a circumstance where you can't wait 2 years after sentencing and go through multiple attorneys. And in this particular case, every time a matter was adjourned and every time a new appellate counsel was appointed, Ms. McEwen, it being advised by the court, this is going to cause a delay. She agreed to the withdrawal, and the court granted the motion to withdraw, not once, not twice, but at least 3 times since the time of her sentencing. These are actions all specifically attributable solely to Ms. McEwen and cannot be pushed off on other counsel.
All right, thank you. Ms. France, anything in response?
Yes, thank you, Your Honor. Unfortunately, Mr. Rolla is incorrect as to the request for transcripts. When you sign the order appointing counsel, Your Honor, it states right on there, this order also serves as the request for all transcripts to be provided to appellate counsel. It's right on the SCAO form. That request was done by your court order, and my staff reached out to attorneys, court staff, and transcriptionists. We did everything we were supposed to do. As far as Mr. Rolla's statement regarding serving me, that very well could be. I've been on the road all morning. I'm in Luce County right now. I haven't gotten the Friday's emails. And the court rules require the response to be filed 5 days prior to the hearing. So with that, I don't believe his answer to the motion should be considered and should be stricken since it wasn't filed timely. Thank you, Your Honor.
All right. I did review the brief, and so I certainly will consider it. The arguments Mr. Rolla has made here on the record are consistent with what was in his brief. But looking at the controlling court rule here, which is MCR 6.425, that court rule gives the court pretty broad discretion to extend or restore appellate rights to a defendant. And in exercising that discretion and looking at potential prejudice, the court finds that there's very little prejudice to the state here in restoring those appellate rights. There's either valid grounds for appeal or there's not. However, balancing that, there is a potential for much greater degree of prejudice to Ms. Hewin if she's not available or not able to pursue her appellate rights solely based on this issue regarding transcripts. So in balancing those two factors, the court finds, and again, looking at the broad discretion provided to the trial court under 6.425, the court finds that it would be appropriate to extend those rights. And so, Ms. France, I'll just ask that you prepare an order and submit that either with the stipulation as to form or under the 7-day rule.
There wasn't one with the original motion, Your Honor?
I believe one was attached to original motion, Judge.
Oh.
At least the copy I got.
Let me check the file, Ms. France. It didn't come with my judge's copy, so let me.
Oh, I apologize, Your Honor.
Okay. No, I'm not seeing it, Ms. France.
I will make sure it gets sent today. I'll do it under 7-day notice so everyone has the appropriate time to object.
Okay.
Judge, if it's convenient for appellate counsel, she can just send it to my office in an email today. I can give her approval and then she can submit it to the court with my permission.
That would be wonderful, Mike. Do you have a different email we should be using when we are serving you?
Government email, mrolla@otsegocountymi.gov.
Okay,
Same thing, it's place and time. Judge, one thing for the rule, is the court referring to 6.425 or 6.428 regarding this restoration of appellate rights? The reason I asked that is because I made a copy of the court rule for today's hearing. If I may approach.
That's okay. I'm sorry. 6.425 governs the appointment of appellate counsel and the appellate rights. 6.428 is the correct court rule that allows the court to restore those rights. So to the extent I said 6.425 on the record today, it should have been 6.428, and thank you for that correction.
thank you, Your Honor.
Okay, thank you. That's all for this hearing today.
Thank you.
On my desk, there is a stack of papers. It's for this Ryman versus Johnson case. Okay. Mr. Trush, just for procedural purposes, are we going to be having an evidentiary hearing in Mr. Haas's case today?
I believe so.
We are. Are you gonna, we need to have him brought up for that? I know. Court rules require that unless there's some kind of stipulation.
Yes, I think so.
Okay. It's gonna be a little bit like everybody may not be here and ready on that until 11:30, so. Okay. Yeah. Oh, I just don't want to have them just sitting here.
Okay.
Yeah. And if we have witnesses that may need to be planning on being here until then. Okay, looks like we have everybody connected. We'll go on the record in our 10:45 hearing. This is Freeman versus Johnson and Prather. This is file number 2319394. The record should reflect the plaintiff, Mr. Riemann, is present by Zoom video. We have Mr. Couch here present today on behalf of Johnston's, and then Mr. Carey here on behalf of Prather's. We have two motions set for a hearing today, as well as a status conference. Both of the motions relate to some discovery. I did have a chance to review both of those motions. Mr. Couch, we'll take up your motion first on behalf of the Johnstons. And anything that you wanted to present today by way of oral arguments for your motion.
Thank you, Your Honor. Good morning, and I'll be brief. Your Honor, the plaintiff sent requests for admissions to the Johnston defendants on August 30th of 2024. The Johnstons' responses were timely filed. In fact, they were filed early with the court on September 20th. I reviewed the court's register of actions. It's available online. It looks like the court actually received them on the 24th of September, which was still early. Now, the Johnstons' motion to strike was filed along with the responses to the request for admissions. And we argued to the court, Your Honor, that the plaintiff did not comply with MCR 2.312F. As the court is aware, requests for admissions are special. If you serve them on somebody or if you file responses, you have to also file them with the court. And the court rule specifically says that requests for admissions must be filed with the court either before service or within a reasonable time. On or about October 5th of 2024, after the plaintiff received our motion to strike, he filed his proof of service with the court. So they were about 5 weeks late, or the proof of service was. I cited to the court in our motion, it's an unpublished Court of Appeals opinion, but it's decently on point from 2015, Rehabitat versus Etherly, which dealt with a 5-week delay in a party filing the proof of service with the court on request for admissions. And that's pretty much what we have here, just about 5 weeks. So for that reason, I asked that the court consider striking the plaintiff's request for admissions. I also indicated at the end, though, Your Honor, that if the court denies the motion and says that they can be refiled, or if they had to be answered, which we did, but I expected he might refile them. They were quite lengthy, 168 requests for admissions in total between my two clients. So that's why in the prayer section, I did ask that the court consider awarding the attorney fees associated with answering the first set. Thank you, Your Honor.
All right, Mr. Couch, I mean, what's the prejudice here? You know, you got him, you answered him, he filed the proof of service. What's the problem?
Well, I will concede, Your Honor, no prejudice. Just want to require the plaintiff, who was trained as an attorney, to comply with the Michigan court rules. And he served requests for admissions on us, and he never filed them with the court. But I will acknowledge no prejudice. We answered them. And I'd remind the court on a positive note, we've got mediation scheduled for Thursday of this week. I'm hopeful of resolving the case. But I wanted to at least preserve this legal argument, so we filed the motion. Discovery has closed.
Okay, and just so that I'm clear, if the court does what you're asking it to do, and then Mr. Riemann refiles, that's going to put you in the position of having to re-answer the ones you've already answered. And so you're asking me to award you costs and attorney fees for having to re-answer when you're the one who's forcing that situation to occur? I mean, is that where we're at?
Well, somewhat, Your Honor. A close inspection of the plaintiff's first request for admissions showed that they were drafted with some inaccurate dates in them. So a lot were denied just because Mr. Riemann had the absolute wrong year of when all of this happened. So I expected he would look at those denials and say, oh, darn, I had the wrong date in here. So my thought is if he reserves them, he would clean them up a bit and put them into a format that we would have to answer differently. But But again, your Honor is correct. There's really no prejudice here. It's just been an inconvenience. Discovery is closed. We have mediation. I half considered just taking the motion off the docket and going forward, but co-defense counsel has also filed a separate objection, and so we left it on.
All right, Mr. Riemann, I'll give you a chance to respond to be frank though, my position is, as I sit here right now, is to deny the motion because there's no prejudice here. And I don't think it's appropriate to require the parties to engage in needless repetition of things. So at the risk of snatching defeat out of the jaws of victory, is there any response that you wanted to make? You're muted, Mr. Riemann, sorry.
Is that better?
Yes.
Thank you, Judge. I appreciate the advice, and I would say I'm certainly capable of what the court has cautioned. I've certainly done it before, but I just want to take a minute to correct the record a little bit. Mr. Couch has said several things that I take issue with. First of all, that he served me with the answers. That's not true. This isn't the first time that this party has filed responses and failed to serve me. The court may recall the answer to the complaint, which was then the subject to some default questions. So right from the start, they would file things but not serve me. And that's what happened in this case. I didn't receive Mr. Couch's motion to quash my request for admission. What happened was, because they didn't answer, I solicited from Mr. Couch his reasoning why he wasn't answering my request to admit. Eventually, he did say, well, we did mail them. Your Honor, all of our exchanges in this case, 100% of them have been by emailed service. And I've never received a piece of mail from Mr. Couch or his law firm or his party. They've always been by email. And in this case, not only did they supposedly make the exception of mailing the responses, they also made the exception of not emailing them to me. So what I did is when I filed the Prather request to admit October 4th-ish, I also took the Johnstons. That was my plan all along. And Mr. Curie had originally, first week in September, asked for some clarification when I served the Johnston request to admit. He wanted to make sure that he wasn't expected to answer them. And I said, no, I will file and serve these all when I finish up the Prather request to admit. And I did that the first week in October. I took them all. It was about 100 some pages, so I didn't want to have to mail in and have the clerks respond with a true copy. So when I had the Prathers ready, I served them on all the parties, and I filed my request to admit. Now, when Mr. Curie took up with me this issue that he supposedly served me with them by mail, which he did not, and Judge, I have it was called informed delivery. So a picture is taken by the post office of every piece of mail I get, and I never received anything on this case. I think I know what happened. That would be subject to a future motion, Judge. But I responded to Mr. Curie and said, look, I did file them. I didn't know you filed a motion to quash. I didn't receive yours. But just so we're clear, I will consider your answers that he then emailed them to me on October 17th. And I said, I'm fine with that. I'll consider that as the answers to both sets. I filed one set. I served them by mail and electronically. So there is no prejudice. And what I want to mention, Judge, is even after I told Mr. Couch all of that in email and in phone conversations, he still re-noticed this hearing. And it's just absolutely frivolous. And I didn't file a motion asking for sanctions, but Judge, I will be. There's other things going on in this case. So thank you for hearing me out on that.
All right, so obviously, again, I did have a chance to review the motion. I don't think it's a frivolous motion. Procedural matters are important. Parties are expected to follow the court rules. That's how our whole system goes forward. And it's important for the court to enforce those court rules when parties don't follow them. So I'm not treating this motion in any way as a trivial matter because I do think it's important. The court rules are there for a purpose. The language that's used is used for a purpose. And again, it's incumbent upon the court to enforce those rules because otherwise no one pays attention to them, and that's where problems occur. So again, procedural matters are important. I don't view it as trivial, but what the court is often called upon to do is to balance where there's a gray area, where there's been substantial compliance with a court rule. And where does substantial compliance begin and non-compliance begin or end? And in this case, the court finds that Mr. Riemann did substantially comply with the court rule, and that in particular, because there's been no prejudice, the purpose of that provision of the court rule hasn't been thwarted by the action of any of the parties here. And so the court finds that it's essentially a solution in need of a problem for purposes of this motion. So for that reason, the court is going to deny the motion, and the court is not going to require Mr. Riemann to refile. Those matters will sit where they are. And so, Mr. Couch, if you can prepare an order and submit that under the 7-day rule on that motion, please.
Thank you, Your Honor, I will.
All right, thank you. Mr. Carey, moving on to your motion, I did have a chance to review that. Anything that you wanted to present by way of oral argument?
No, but thank you for the opportunity, Your Honor.
Okay, Mr. Riemann, as to Mr. Carey's motion on behalf of the Prathers.
Judge, I'm going to have to refresh my recollection here a little bit. I don't believe I got a notice of hearing setting that for today, and so that's the reason I didn't reply to it. I know Mr. Carey was out of the office, and he and I had signed a stipulation to agree to continue discovery at his convenience and at my convenience beyond the date of the close. So I did not respond to that. I recall that there was an objection as to, I'm sorry, perhaps my interrogatories exceeded the 20 limit. I did respond to Mr. Carey in writing and apologized. I had in mind the federal rule, which allows 25, and I wanted to make sure I kept it to that. So I did file and serve on Mr. Carey after he filed his motion, an amended discovery request, withdrawing an amount to bring me down below the 20. And I did similarly with Mr. Carey, as he indicated, I had some typographical mistakes or dates or addresses wrong, and I did correct those with him, but I didn't see the need to file an amendment with his because his clients are basically denying everything. So there's no reason to follow up on some of the details that I had made a mistake on. But as to Mr. Carey, I think I've brought my request into compliance, and he and I have agreed to continue our discovery without delaying the case as the court proceeds.
Your Honor, if I may, I have been gone for 2 weeks, and this is my first day back, and so frankly, the court's inquiry of me taking a position on my motion took me by surprise. I don't believe I noticed it up. I think I simply filed a motion to preserve the issue. I think that's true. And what Mr. Riemann has advised the court in terms of his attempts to bring his interrogatories into compliance with the Michigan court rule is also correct. I would simply like to leave my motion pending. I haven't had a chance to see whether the subparts of the amended interrogatories really comply with the rule or not. If the amended interrogatories are in compliance, I'll notify the court that I'm withdrawing the motion. If the amended interrogatories, in my view, are not in compliance with the Michigan court rule, then I would propose that I would notice that my motion that's been filed up for review. I think the Johnstons have a hearing scheduled for January 6th, sometime in early January, and I'd probably use that date if that's okay with the court.
All right, so since I think we all agree that motion hasn't been noticed up for hearing, the court is not going to make a decision on that issue. Which leaves us for the last matter, which is a status conference. Based on what the parties have indicated, if we all agree that mediation is scheduled to occur later this week, then my proposal would be that the court set this for another status conference following mediation. Does anybody have any objection to that, Mr. Riemann?
Well, if I might comment on mediation, Your Honor, I have proposed to council after I received the balance of the discovery responses. It's pretty clear, Judge, we're diametrically opposed, not only as to the question of whether there should be any damages, but even on the underlying condition, which I've asked the court for equitable relief to restore the previous drainage condition and situation at the Johnston property with mine. And I think we've come a little ways in terms of resolving whether we're going to call it a drainage channel or a ditch and the location of it. But I don't think there's any sincere possibility, Judge, that the parties are going to resolve that. And so council and I also, I tried to initiate a discussion. Hey, is there any way we can resolve these issues? There's never been any settlement discussions. There's really, it's very unlikely that all the time and energy and amount we're going to spend on that mediation would prove successful. So I am asking the court to consider canceling that as not really having any hope of resolution. And Judge, it is a very expensive process. The mediator submitted a request that we limit our submissions to 15 pages and to exclude lengthy exhibits. Frankly, she disfavored any exhibits. And within a week of that, Mr. Couch filed a 240-page submission. So exceeding the limit that the mediator set by over 220 pages. And included extensive exhibits, much having nothing to do with the merits of the case, most having nothing to do with the merits of the case. Judge, it's not a sincere, not a likely outcome of success. We're nowhere near it. And Mr. Couch is welcome to contact me anytime he wants to discuss resolving any of these issues. And as I've said, I've tried to initiate, and they've all been ignored. And in light of their denials of the condition recently in the request to admit, I don't see, I would love it if we were able to resolve it. Judge, I just don't see any hope at the current status of the parties' positions of that happening.
Thank you. Mr. Couch or Mr. Carey?
Your Honor, if I could address that first. I have not agreed to Mr. Riemann's request to extend discovery for a couple of reasons. Discovery closed on November the 2nd. Mr. Riemann never did take the depositions of my clients. What he would do throughout discovery is, for instance, about 5 days before discovery closed, he said he wanted to take their depositions. I mean, he never gave reasonable advance notice. Discovery has closed. He never filed a witness list. I have all along planned to file a motion for summary disposition, which I have now done, and that is pending and scheduled to be heard by the court after the holidays. He wants to reopen discovery so that he can take depositions that he never took before. Your Honor, once again, never filed a witness list, has not retained a single expert. And this is a case that requires expert input to resolve these issues of engineering and slope and topography. The defense has experts, the plaintiff doesn't. Mr. Riemann realizes that his case is in poor shape, and that's why he wants to do more discovery. And I disagreed because I needed to file my motion for summary disposition. With regard to mediation, we filed a 20-page summary. The rest of it is all exhibits. Some of those pages are complete photographs. I didn't receive an objection from the mediator, and I want to go forward with mediation. Even though we took a strong position in our mediation summary, the court knows mediations settle cases. And if all of these parties spend the day together later this week, we might be able to hammer out an agreement and get this case done globally. So I would ask that the court not cancel the court-ordered mediation and not reopen discovery and allow it to go forward as the court originally ordered.
Thank you, Mr. Carey.
I'm a fan. I think the court knows I'm a fan of mediation. I participated in lots of the mediation hearings where expectations were low at the onset and the cases ended up resolving. I'm inclined to want to go forward. I know it's difficult though, sometimes when you have a motion for summary disposition pending that is going to be heard post mediation. And I know that can create some difficulties, but counsel, Mr. Couch has said that he and his clients are approaching mediation in good faith and optimistically, and I'm inclined to believe.
All right, I have no reason to, in this case, bleak as the prospects may be, not to require the parties to proceed with mediation. I do that in almost every case. I think it's appropriate here. I think all parties need to come to the table in good faith, and we'll see where it goes. So the court's going to order that mediation continue as scheduled. Knowing now that we do have a motion set for January, I'll just set the status conference for the same time as the current motion. So that's all I have for today. Thank you all. All parties are free to disconnect at this time.
Your Honor, just
thank you.
one final housekeeping question. Since the court charged me with preparing an order denying the motion to strike, would you like me to include language in there adjourning the status conference to the date in January of my motion, or will the court do that separately?
That would be great. Thank you.
Thank you, Your Honor.
Okay. All parties
Thank
are
you,
free to
Judge.
disconnect.
Bye all.
Next hearing set for 11:30 will be off the record until then.
do have a copy of the signed judgment if you'd like.
Yes, please. All right, Miss, how do you pronounce it? Is it Nickel?
I go back and forth.
Ma'am, can you hear me okay?
Yes. Can you hear me?
Yep, and then Mr. Nickel, are you there too?
Yes, I am.
Okay. Okay, we're on the record. This is case number 2419729, Nickel versus Nickel. Both parties are present by Zoom video here today. Ms. Bailey Quick is present here in the courtroom on behalf of plaintiff. I have this set as a date to take proofs and enter a judgment of divorce. Ms. Bailey Quick, is that how you and your client want to proceed?
Yes, Your Honor, thank you.
And Mr. Nickel, is that how you wanted to proceed as well?
Yes, that'd be fine.
Okay. Ms. Nickel and Mr. Nickel, I can't see you, but if you can both raise your right hands, and Mr. Nickel, if you can tell me once your hand is raised, please.
Yes, it's raised.
Do you both solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, I do.
Yeah.
Okay, thank you. You can both lower your hands, and Ms. Bailey Quick, if you want to conduct your questioning of Ms. Nickel.
Thank you. Charity, would you please state your name and spell your last name for the record?
My name is Charity Lynn Nykel, Nykiel.
Thank you. At the time you had filed your complaint for divorce, had you been a resident of the state of Michigan for at least 180 days?
Yes.
And at that same time, had you been a resident of Otsego County for at least 10 days?
Yes.
Were you legally married in Argos, Marshall County, Indiana on May 18th, 1996 by a person authorized to perform marriages?
Yes.
And are you currently pregnant?
No.
You and Mr. Nickel do not have any minor children left born of the marriage, minor children. You have adult children, correct?
Correct. Yeah, no minor children.
Mr. Nickel, we'll ask you questions next. So if you can just hold off for right now, please.
At the time you filed your complaint for divorce, you had alleged that there had been a breakdown of the marriage relationship to the extent that the objects of matrimony had been destroyed and there remained no reasonable likelihood that the marriage could be preserved. Was that true at that time?
Is this for me? Yes,
Yes. And does that remain true today?
it does.
You and Mr. Nickel participated in mediation and you reached a full resolution, and that's been reduced to the judgment of divorce. You've had an opportunity to review and sign that judgment. And ultimately, are you asking the court to enter that judgment?
Yes.
Are you asking the court, let me rephrase that. You are not asking the court to return to any former maiden name, is that correct?
Correct.
All right. And in the judgment, it provides that neither you or Mr. Nickel will receive any type of spousal support. And you understand that after entry of the judgment of divorce, that both of you are forever barred from coming back and asking the court to modify that provision.
Yes.
Do you believe that the judgment is a fair and equitable division of your marital estate?
I do.
I don't have anything further.
Thank you. Mr. Nickel, have you heard all the questions that were asked of Ms. Nickel?
Yes, I heard all of those.
Did you hear all of her answers?
Yes.
Do you have any reason to believe that any of the answers that she gave were untrue?
No.
And as Ms. Bailey Quick indicated, you also will not be receiving any alimony or spousal support as part of the divorce. Is that correct?
That's correct.
You understand that you would be waiving that forever as well, and you would not be able to come back later and ask the court for that?
Yes.
And I have a copy of that judgment that was signed by you on November 4th of 2024. In signing that, does that indicate that you agreed to abide by all the conditions of that judgment?
Yes.
Okay, thank you. Ms. Bailey Quick, did you have any questions for Mr. Nykel?
Nope, you covered all of them. Thank you.
All right, the court finds that the statutory grounds for divorce have been met by the testimony of both parties. The court will grant the divorce and signing that judgment with today's date. Mr. Nykel, did you have any questions at all?
No.
Ms. Nykel, did you have any questions?
No.
All right, thank you. That's all for this hearing today. Both parties are free to disconnect. And Ms. Bailey Quick, I'll get you back that judgment that's been signed. And that's all for this hearing today. Thank you.
Thank you.
Okay, last matter is Haas versus Haas, case number 22-19142.